Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the National Accreditation Regulatory Authority Bill 2010. To discuss the issue, I have with me Mr. R.P. Sisodia, Joint Secretary, Higher Education, Ministry of Human Resources Development, Professor Saidi Hasnain, Member, UGC and former Vice Chancellor of Hyderabad University, and Manan Kumar Mishra, Chairman, Bar Council of India. Now for the headlines. The bill seeks to set up a super regulator for agencies granting accreditation in higher education. No agency will be allowed to grant accreditation without registration from the proposed authority. Accreditation of universities granting higher education will be mandatory for ranking of institutions. The National Accreditation Regulatory Authority Bill 2010 seeks to set up a national authority which will be a super regulator of agencies who grant accreditation in higher education. The accreditation agencies will have to obtain a certificate of registration from the national authority, and then only will it be allowed to accredit institutions of higher education or learning.
Indian students seeking admission abroad for higher studies face several issues, as Indian degrees are not recognized by foreign universities. Even for students wanting to study at home, there is no ranking system of universities which could guide a student in deciding what university to go and which university to avoid. It is this that the government intends to solve by bringing in the National Accreditation Regulatory Authority. The bill seeks to make universities accountable by rating them under one legal framework.
There is one clause which says that one particular accreditation agency's certificate can be cancelled by the government if they get into fraudulent activities. Not only that, if that happens, then whatever institutions they have given their certificates over the last 1 year would also be reviewed. So, these institutions of higher learning which have by fraudulent means got a certificate from accredited agencies will not be able to escape.
According to the bill, the National Accreditation Regulatory Authority NARA will be the super regulator, and all accreditation granting agencies will be registered with it. Let us look at some of the eligibility criteria that the accreditation agencies will have to fulfill to be registered with the NARA. The applicant must have in its Memorandum of Association MOA accreditation of higher educational institution as one of its main objects. The applicant must have adequate infrastructure, it must have prescribed professional competence, financial soundness and general reputation of fairness and integrity. The applicant must have adequate professional as its employee. Let us look at the role that the NARA will be expected to undertake. It will lay down norms for the assessment of academic quality in universities, which will be conducted by the rating agencies. It will periodically review the norms and audit the agencies on matters of conflict of interest, information disclosure, transparency and levy of fees. The authority will also lay down policies on what must be disclosed to the public relating to the quality and performance of institutions. It will also monitor the standards on selection and training of experts on accreditation. The bill also allows an institution to appeal to NARA for modification of the rating given by an accreditation agencies.
Medical Council of India itself is a regulatory body, and bringing under bill might create confusion or overlapping, and further improvements could be done, like involvement of the accreditation agencies in the Medical Council itself.
The authority will consist of a chairperson and 4 members. One of the members will have to be a woman. They will be appointed by the central government on recommendation of its selection committee. The members and the chairperson will not be allowed to hold any office in education sector for a period of 5 years after their tenure is over. Subina Roy, Rajya Sabha TV.
The Parliamentary Standing Committee has advised that the strength of NARA be increased from the existing strength to represent various stakeholders. As of now, NARA has just 4 as its strength. My question to you, Mr. Sisodia, first question. In the event of cancellation, the point that was brought out, in the event of cancellation of registration, what is the implication, and does the bill ensure that the implications are not disastrous?
The bill ensures that the cancellation of registration of an accreditation agency, once it is done, it has to be done by the authority. The authority has to give an opportunity of explaining its stand to the accreditation agency, and only when the authority is satisfied that the accreditation accorded by the agency has been substantially irregular or there have been very major irregularities noticed, then only the accreditation agency's license will be cancelled. Once the license is cancelled, all the accreditation ratings that the agency has given in the last 1 year would be reviewed by the authority, so that in case an accreditation is granted wrongly or an accreditation is questioned, then in such a case the accreditation can also be, the rating as well as the accreditation status can be modified by the authority. Authority has the powers. So, the bill ensures that the students and the institution, its interest would be safeguarded to the extent that it has obtained accreditation. If it really qualifies on all those parameters, then certainly the authority would not change it. The accreditation rating would be changed only in case it is found that it was given due to certain wrong representation or misrepresentation of facts about the academic quality of an institution.
I'll bring in Professor Said. Professor Said, the point that was brought out by MCI, they are an accreditation agency. They say, and there are several such, you've been part of one accreditation agency, there are several of them. Do you see a conflict happening, confusion happening, and overlapping of powers? In fact, we have got one of the accreditation agencies with us, the Bar Council. I'll come to you, sir.
Yes, I think on the face of it, it does seem to have a conflict, but if you really look into the exact exercise, I don't see any conflict. The main agenda here being that you are trying to bring in a quality standards, in which case there is no conflict. Every educational system, whether it is medical education or legal education or technical education or higher education, they all need to establish some contours of excellence. So, there is no conflict. The conflict only comes when you perceive who will do it, and that is where I think one has to tread carefully. The original version did not specify who would be doing this, but now I understand the revised version, which will go to the parliament again, this issue has been taken care of. As long as you ensure that the stakeholders are involved, I don't see any conflict at all.
Bar Council, yes, Mr. Mishra.
So, there is overlapping, that is sure. We are the regulators, and we have under the Advocates Act a statutory legal education committee.
Right.
It is a well equipped legal education committee constituted by the Bar Council of India. This legal education committee is headed by a former judge of Honorable Supreme Court. One of the members of this legal education committee is the sitting Chief Justice of a High Court.
Oh.
We have UGC chairman as one of the members of the committee. The Solicitor General of India, Attorney General of India
Our members.
are the members.
Yes.
Apart from them, the academia like Mr. Madhav Menon, NL Mitra,
Yes.
they are our members. We have included Mr. P.P. Rao, several legal luminaries.
What you're
in
saying
our-
is there is a problem on that front. Are you trying to say a super regulator headed by an academician will now have to monitor the doing or undoing of a judge?
of a judge.
Do you think that's allowed, permissible?
No, that is not at all permissible. I don't think that any sensible person, any sensible authority will accept this theory.
Mr. Sisodia.
Let me clarify a few things. See, in this Indian higher education scenario, you have one entity which is called regulator, that is statutory regulatory authority. These regulators happen to be Bar Council of India, it could be Medical Council of India, it is
AICTE,
it is UGC.
Whole
They
lot
are
of them.
supposed to regulate that field of higher education which they are concerned with.
Right.
They lay down norms and standards. No one is going to tamper with these norms and standards.
But they will have to seek registration.
Now there is a difference here. What happens is that this accreditation is an independent process. An independent, let us just for a moment give the analogy of the credit rating agencies. There are regulators in the credit sector. These rating agencies only from an independent point of view, from an independent perspective, they just look at your credit worthiness and accord you some rating. They do not tamper. Suppose SEBI has laid down any guidelines or a regulator has laid down any guidelines, then they do not. See here, this regulator, the what super regulator that we are talking about is not a super regulatory authority.
But
It
registration
only
is mandatory.
accreditation.
Registration is mandatory. Compliances are mandatory.
No, just a moment. You see here the regulator is separate, the accreditor is separate, accreditation agency is separate. What this authority is going to do is
Grant
it
registration.
is going to regulate the functioning of the accreditation agencies.
Exactly.
It is nowhere going to interfere in the functioning of the regulators. Let us say, let us say for a moment that Bar Council lays down standards that this should be the standard of academic quality, this should be the curriculum, this should be norm of teacher student ratio. Now, what this accreditation agency is going to do is assess an institution as to whether
They are
what
doing it or
extent
not.
it is following. So, there is no conflict as such, and
So the term super regulator doesn't apply. Is that what you're trying to say?
it is a super regulator only for the field of accreditation.
Exactly.
It is not a regulator for regulating the higher education institution.
I get it.
There is a difference.
It's time for us to head into a break. When we come back, we will tell you about the penal action proposed in the bill. Welcome back. The bill makes accreditation mandatory for all institutions and programs in the higher education sector so that ranking of institutions can be achieved. The only exceptions provided in the bill are institutions imparting agricultural education. Failure to comply with the law will be punished with fine and even imprisonment.
According to the Parliamentary Standing Committee on Human Resource Development, most of the existing 16,000 odd colleges operate under affiliations. In the absence of proper infrastructure, many colleges perform only classroom teaching, resulting in poor quality of MSc, MA, PhD qualifications.
Well, if the agency doesn't have the power to downgrade any institution, then why have the agency? So that power has to be given to the agency. Hopefully, they will use it in a very imaginative and proper manner. And I would like to say that given our own knowledge on this is very poor in the country, except NAC, which has done something, so we should follow what NAC has done and try to improve upon that.
As of now, the accreditation process is being done by the National Accreditation Board and National Assessment and Accreditation Council for those who volunteer to be accredited. But the bill now seeks to make it mandatory for every educational institution to be accredited by accreditation agency. An accreditation agency means a non-profit organization registered as an institution under the Companies Act, Societies Act or under the Trusts Act. The agency has to be a state or central government entity. The agency will be expected to rate the institutions based on prescribed parameters. Only a registered accreditation agencies will be able to undertake accreditation of a higher educational institution. If an accreditation agency fails to comply with its duties, it will have to pay compensation to the higher educational institution. Any accreditation agency that violates the law will be punishable with a fine of up to 5 lakh rupees. If any person resists or obstructs any officer of the authority, he will be penalized with imprisonment up to 3 months or fine of up to 5 lakh rupees or with both.
The negative aspect is that the government still has the power to exempt any class or classes of institutions from the purview of the accreditation, and that is where there can be misuse of the act. So, that I think is a negative side of it.
The bill gives the central government powers to exclude any class of institution from this law. But the Parliamentary Standing Committee feels this may lead to influential institutions getting exemption from rating. So it recommends that in order to prevent such things from happening, the clause providing for exemptions should be deleted. Subina Roy, Rajya Sabha TV.
The bill precludes institutions providing agricultural education on the grounds that it is a state subject. The Parliamentary Standing Committee is of the view that there is no justification to deprive students of agriculture from the benefits of mandatory accreditation. My question to you, Mr. Mishra, do you think your accreditation agency, the Bar Council, would like to seek exemption under the powers to exempt?
Yes, yes, that is what we are telling. We are demanding that this legal education should be actually kept aloof from the purview of this bill, because we have already a very good infrastructure for that. We have these rules of 2008 itself. We have a separate accreditation committee under the legal education committee. Though up till now, since the law was not to make it mandatory, it is only voluntary or optional.
Right.
But since now we are aware of the intention of the government that it should be mandatory, we will do it. There is no problem for us.
Mr. Professor Said, do you think UGC should also try for exemption?
No, I don't think, I disagree here. I think the philosophy will be diluted. The whole purpose is to ensure across the board in all forms of education. So I think it's important that everything, we have to accept the individual problem, individual cases on a different platter, but not giving exemption. While having said this, I still feel there should be room left for some institutions of excellence. For example, in the original bill, they have already talked about the All India Institute of Medical Sciences, the IITs. I think there is a merit in exempting them. The merit being they have already reached a level,
attained a level of excellence.
The counter argument could be that, well, in that case, tomorrow if they fall down, but I think today we are living in a world where people are evolving into higher levels of excellence. The IITs of yesterday and IITs of today have to survive. So I don't think this argument works. So I would still go by the original suggestion that it should be across the board for all levels of education.
Standing committee also feels the same. Mr. Sisodia, do you think now when the bill goes to the Parliament, with the building into this bill the recommendations of the Standing Committee, do you think we are in a position to do away with the clause of exemption or continue to include it?
After examination,
do we require it?
See, as Professor Hasnain has very rightly pointed out, and also as Mr. Mishra is saying, that there might be a need which may arise in future to exempt a particular class of institutions or a few institutions from the purview of mandatory accreditation. In such a case, it would be needed that this clause remains. However, this clause actually gives power to the government to exempt, and the government has to always act in proper after applying all the criteria and also see whether a real case, a genuine case exists for exempting a particular class or a particular institution from purview of the Act. And once the government exempts, it has to be done through a notification, and that notification will be in the public domain, and certainly the government will exercise due discretion while granting such exemptions. But as has been pointed out in the Parliamentary Standing Committee report also, that some of the institutions, the medical institutions, they have already made a plea for exemption, like AIIMS or institutions of national importance or IITs. So, in such a case, a safeguard clause would certainly be required to be there in the bill. Otherwise, it may necessitate amendment at a later date.
It's time for us to head into a break. When we come back, we will show you an interview with former chairman of UGC, Professor Sukhdev Thorat. Welcome back. My colleague Aruna Thakur spoke to Professor Sukhdev Thorat, former chairman UGC, and tried to get his perspective on the issue.
There are already statutory authority who are checking the academic quality in India. So what is the reason behind to bring up a new national accreditation regulatory authority?
No, I think those aspects will be taken into account while framing the bill and passing the bill. But what is important of this bill is that given the issue of quality, what does this bill propose to do is to make it compulsory for all private and public education institutions to get evaluated and get accredited within a given period of time. For new institutions, they are giving, it's compulsory for them before they start any course, and for the existing institution, they have been given 3 months time. Now, with the proliferation of the private institutions in large number, there is no way whereby we can really regulate the quality. So, this bill is an attempt to have a quality assessment and quality control and monitoring of the education institutions. And to that extent, it is an extremely important bill in my view, which will ensure that the quality is a minimum quality is maintained with respect to indicators of quality assessment.
How the students will going to benefit with this law?
Student will benefit from it because they will get to know the grade and level of the quality of the various educational institutions. So, I think in a situation where private sector is playing a major role, that you can start any educational institution by registering a society or a trust or whatever and meet certain condition, quality assessment is very, very important. To that extent, this is a very important step forward by the MHRD.
Don't you think that the proposed National Accreditation Regulatory Authority will have clashes with the existing statutory authority?
No, what they are doing, that they are resolving all those conflicts. I understand that the NAC will be one of the assessment authority. In fact, they are conceiving the multiple assessment authorities, which will be granted by this authority as such. So, I think I do not see any conflict, and I think the ministry will has already expressed that they will take those legal things into account, and that after that the bill will be passed.
The Parliamentary Standing Committee termed the provision to allow any person aggrieved by the decision of an accreditation agency to apply to NARA for withdrawal or modification of such accreditation as vague. It advised that a grievance redressal mechanism be put into place to ensure transparency. My question to you, Mr. Sisodia, what are the changes that have been already put into or built into the system post the Standing Committee report? What are the new changes?
Based on the Standing Committee's report, whatever recommendations that given, we have made certain significant changes in the bill. One of the main changes, as has been pointed out, the authority so far consisted of only 4 members.
Right.
So, we are making it a 8 members body, out of 8 and 1 chairman. So, 8 members, there would also be out of the 8, 1 has to be an expert in the legal arena and 1 has to be an expert in the medical field. So, one is broad basing the authority. The second significant change that we have made now is that before an institution commences the academic operations, it has to undertake what is called assessment. Assessment is some kind of evaluation of the existing infrastructure, etc., for an institution before it starts enrolling students. And accreditation is the process which takes place after the institution has completed certain period of existence. So, accreditation, since it takes into account the teaching, learning quality, the outcomes of research, the learning outcomes, or how the students have actually passed out on what grades and all that. So, after 6 years of existence of an institution, accreditation shall become mandatory. In the beginning, it will be only assessment which has to be undertaken, which also shall be mandatory. So, we have given 6 years time frame for the existing institution to undertake the accreditation. And also in this the bill, now 1/3 of the members, that means 2 members have to be women.
Okay, from 1 to 2 it has become
8, and 1 member from the deprived, 1 from SC community and 1 from ST community. Okay. That change we have made.
Professor Said, does that answer your question? Your
partly. I would suggest that when you are going to expand the membership, why don't you make ex officio the chairman of the bar council, ex officio chairman of the
all of them into the body
as a body, instead of saying experts. That way they will also represent their own voices of the respective thing. The second issue which Mr. Sisodia answered partly See, we have not still been able to resolve, at least not to my understanding, the revised version. How is NARA going to be different from being an accreditor itself? So that conflict of interest issue, to my knowledge, Mr. Sisodia
is not being sorted out.
Is not been sorted out.
Yeah.
That is.
I get it. I'll bring in Mr. Manan Mishra. Mr. Mishra, you were making a point that during the consultation process,
Yeah.
Bar Council of India, which is an accreditation agency, a regulator, was not consulted.
Not at all. Neither the HRD ministry nor the Standing Committee of Parliament. We were never consulted. Otherwise, we would have placed our case. We would have furnished evidence, sufficient evidence to show that we have sufficient infrastructure for the purpose. We are already doing it. Only thing that it has to be done on mandatory basis, that we are able to do.
Right. Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.irastv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.